Well, good morning, everybody, and welcome to this tax planning webinar brought to you by DFDL. My name is Stephen Higgins from Mekong Strategic Partners, and I'll be the host for today. With me on this webinar, I have Clint O'Connell to talk about the government's new investment incentives, followed by a session with Jack Sheehan and Borapyn on cross-border tax issues. And finally, Clint and Jack will come back and talk about some of the tax issues that might arise when exiting an investment in Cambodia. If you have questions along the way, please write them in the Q&A box on the screen and we'll endeavour to cover them as we go along. Or if we don't get to them, someone from DFDL will get to you after the webinar. Now, I know that tax planning can be a pretty dry subject. It's not the sexiest thing in the world, but we've seen a number of companies recently run into multi-million-dollar problems lately as a result of some of the topics that you'll hear about today. So this stuff, it can matter a lot. Now, before we get into that, we just wanted to set the scene for the new investment law. So if we can go to the next slide. And the one after that. And the one after that. Okay, so the Olympics are on, getting into the spirit of the Olympics. Back in 2014, the World Bank identified Cambodia as an Olympian of growth. It had the sixth fastest growing economy in the world over the previous 20 years to 2013, which is a pretty extraordinary performance, sixth best in the world. If we roll that forward 7 years to 2020, Cambodia has kept that sixth place, despite a sharp slowdown last year. So over the past 7 years, they've continued this really strong growth performance relative to other countries in the world. So it's something that we shouldn't lose sight of. Yeah, things are tough at the moment, but excluding COVID, Cambodia is fundamentally a high growth economy. Moving to the next slide. So we see that sharp downturn in 2020, it's basically a 10% drop from around 7% to -3%, which is one of the largest falls in the world. And I'm sure that we all felt it here in Cambodia. We think that there's going to be a small rebound this year to around 2%, which is slightly lower than the government's forecast of 2.5%. Now, you'll note on the right there, the World Bank, ADB, IMF, they're at around the 4% mark, but those forecasts were made earlier in the year before the 20th of February event really made its mark, and before the length and depth of this current outbreak was known. Moving to the next slide. We look at where the government thinks growth is going to come from. This data is from the MEF from a little bit earlier in the year. And for the most part, we agree with their thinking here. The first thing to note is that agri isn't going to grow much. Now, this is a secular trend that's not going to change. And this is not unique to Cambodia. This is the case in most countries around the world. Agri is just not a driver of growth. We shouldn't underestimate it, but it's not a driver of growth. Industry should see some decent growth driven by a rebound in global demand. Now, although I'm not as optimistic as the government on construction, I think that sector is going to find the next couple of years fairly challenging. And when you look at what's happening on the Phnom Penh skyline, there's going to be a lot of vacancies for the next little while. On the services side, particularly hotels and restaurants and retail trade, where we're pretty pessimistic on the outlook for this year, and for tourism generally, for probably the next 2 years, driven by people just aren't going to be flying in here for quite some time yet. But once we get to the outer years, 2023, 2024, we will become a lot more optimistic about tourism than what the government numbers show. If we go to the next slide, we look at where the investment approvals have been over the past 5 years, based on CDC approvals. So They're approvals only, they're not actual investments that have been made, but it's still quite illuminating. So you'll see that tourism infrastructure at 44% has dominated investment approvals. But that's the sector that's also been decimated by COVID and is going to find things harder still for the next couple of years. And I think it's fair to say that in that sector, there's now a lot of surplus capacity as well. What I find disappointing on this slide is that only 24% of approved investments are in the industrial sector. And my one big hope is that the new investment law encourages greater industry investment outside of garments. But let's stop looking at the past and look a little bit more to the future. If we can go to the next slide. So for the period ahead, we're fundamentally optimistic about Cambodia and what lies ahead. We're expecting growth in 2022 to rebound above 6%, supported in part by Cambodia's exceptional vaccination performance. And we shouldn't underestimate what a great job the government has done with that. And that will allow Cambodia to open up quicker than most other ASEAN countries. And if you think more generally about the government's response to COVID here and how they've dealt with the vaccinations, outside of Singapore, potentially Vietnam, Cambodia has done a better job here than any other country than ASEAN. Right? And we shouldn't lose sight of that. We think growth in the coming years, going to point number 2, will be supported by improved infrastructure. If you've been down to Sihanoukville lately, you'll have seen a remarkable and positive transformation. And something similar is happening in Siem Reap now as well. I was up there just last week, had to make a mad dash out to beat the border closures. But if you roll forward 12 months, these cities, they're really going to be transformed. There's continued investment in energy, including in the grid, along with logistics infrastructure. Now, there's still a long way to go, and we shouldn't lose sight of that, but it's heading in the right direction. And for investors coming in, they're concerned about the direction that things are heading, not so much about where they are today, but is it heading in the right direction? And in Cambodia, the infrastructure is absolutely heading in the right direction. Thirdly, geopolitical forces, you can never ignore them. They will see manufacturing continuing to switch out of China, and particularly to Southeast Asia. So Vietnam, we've already seen as a big beneficiary of that, and Cambodia will increasingly benefit from that as well. Now, it goes without saying, I think, that the previous investment golden child in this region, Myanmar, is just no longer an investment destination. So that, again, is going to support the Cambodia story. Fourth, the pre-COVID advantages still apply. Right? So there's location, macroeconomic stability, whether that's exchange rate, inflation, interest rates. They may not be where you want them to be, but they're stable, and investors like stability. And then you've got relatively cheap labour. It's gone up a lot in recent years, but it's still at a price point that is attractive to those industries, manufacturing industries that do rely on cheaper labour. Finally, and perhaps most importantly, we have supportive government policy, which has been the case for a long period of time now. But the government also understands, particularly in this, as they look to the post-COVID period, the need to continue encouraging investment. Now, I think that's probably a great segue to bring in Clint now to talk about the new investment law and what that will do to encourage more investment coming into Cambodia. So, Clint, over to you.
Okay, thank you, Stephen. As you can see from the general theme of Stephen's slides, we're fairly optimistic with respect to the continued growth for Cambodia over the coming years once we get over this COVID disruption. One of the key tools that we see in helping to put Cambodia back on track and to encourage FDI into Cambodia is the new investment law. So my topic today is going to be looking a bit further and in more detail at the proposed investment incentives that will be contained in this new investment law. Next slide, please. Next slide. Next slide. So where are we now with the investment law in Cambodia? So just last month, the Council of Ministers in Cambodia gave the green light to the new investment law. That was after a few years of consultation between the Cambodian royal government and the business sector in Cambodia. So following the approval by the Council of Ministers, the next step to get this investment law in place is for an approval by the National Assembly and the Senate in Cambodia, and then finally the promulgation of the law into force by the King. So realistically, we expect that to happen late 2021. Most probably to be in effect from the 2022 calendar year. So the new law on investment will not be a one-off single piece of legislation. There will be a series of legislative updates, including a new law on special economic zones, and then there will be sub-decrees to provide the finer detail with respect to the implementation of the investment law and the law on special economic zones. Next slide, please. So as Stephen touched on in his slides, the long-term goal of the Cambodian government is to try and move from labour intensive industries such as the garment factory reliance that Cambodia currently has, and try and push or encourage new investments, particularly that are in the high value added sector, and also to try and encourage additional technology, e-commerce industries into Cambodia. We've seen in the past that over-reliance on one particular industry, putting all your eggs in one basket cannot be such a good thing when there is external factors which may influence that reliance. Next slide, please. So again, the main theme of my topic today is looking at the investment incentives that will be contained in the new investment law. To do that, we really need to have a quick overview of the current investment incentives, because as you will see, there is a little bit of continuity between the existing law incentives and the proposed incentives under the new law on investment. Next slide, please. So the cornerstone of the current investment incentive regime in Cambodia for qualified investment projects, which are effectively projects that are approved under the investment regulations in Cambodia, is this tax on income exemption. So tax on income translated to the corporate tax exemption in Cambodia. So currently a qualified investment project can be eligible for this tax on income exemption period, which contains three key elements. We have a trigger period, which can be anywhere from 1 to 3 years, dependent on when the QIP first derives revenue or first makes profit. Then typically all QIPs would be eligible for a 3-year tax holiday period. And then finally, we have this priority period, which can be anywhere from 1 to 3 years, depending on the type of industry that the QIP is in, and depending on the amount of investment capital of that QIP. And then following the tax on income exemption period, a QIP would then have to pay the standard corporate tax rate in Cambodia, which for most taxpayers would be 20%. Next slide, please. So historically, as tax advisors in Cambodia, assisting QIPs, one of the key aspects that we had to, I guess, educate and inform our clients was that this historically, this tax on income exemption wasn't really a permanent tax exemption, insofar as a QIP that made profits during its tax exemption period and did not have to pay corporate tax at that time, unfortunately would have to pay the corporate tax at the time that it distributed dividends from the retained earnings that benefited from the tax exemption period. So practically speaking, all that this incentive did was to suspend the application of the corporate tax in Cambodia until such time as the QIP was to distribute a dividend. And this caused a few issues for investors. One was, okay, if we want to get our profits back in a fairly short period of time, the effective tax rate on a dividend distribution would be around 31.2% when you take into account the clawback of the 20% corporate tax plus the 14% withholding tax that would normally apply on dividend distribution by a QIP to a non-resident shareholder. So sometimes what investors look to do was to effectively keep the profits in the QIP, not distribute any dividends, and then try and exit their investment via a share transfer. And back in the day in Cambodia, that was quite a tax-effective way of exiting your QIP project, particularly if you were resident in a jurisdiction like Singapore or Hong Kong that didn't tax capital gains. That effectively meant, in most cases, that you wouldn't have to pay any tax in Cambodia if you were the exiting shareholder. Another way that a technique that was used by QIPs to try and get around this this clawback of the corporate tax was to try and introduce intercompany charges above the line, thereby reducing the amount of retained earnings that would be affected by a future clawback. And so we see the introduction of interest payments or royalty payments or management fees, whereby the QIP would still have to typically pay withholding tax of 14%, but paying 14% was a lot more efficient than paying 31.2% in a dividend distribution scenario. Next slide. So a bit of a game changer happened, and to be quite frank, we kind of see this change as probably even more fundamental than the incentives that have been proposed under the new law on investment. So in 2020, a new praka on tax on income was introduced by the Cambodian government. And the key change that was introduced by this new praka was that for a QIP that benefited from the tax on income exemption, when it came time for that QIP to distribute dividends to their shareholder, there would no longer be a clawback of the tax on income. So what that basically means is now this tax on income becomes a permanent exemption. It doesn't become just a suspended benefit. And to us as advisors, this was a real game changer. This provided significant savings for new QIPs looking to come to Cambodia. Next slide. And so we can see this quite clearly illustrated in these two examples. So prior to 2020 and the introduction of this new tax on income PRACA, we give the example here of a QIP that had retained earnings in 16, 17 and 18, which benefited from the corporate tax exemption. But at the time that that QIP distributed a dividend from those retained earnings, there was a clawback of the corporate tax that was called additional tax on income. And then on top of that additional tax on income, we would have a 14% withholding tax on the dividend distribution. So if you have a profit of $4 million, you're having to pay around 1.2 million of that to the tax department in Cambodia before you got your profits back. Next slide, please. So you can see the difference. You can see the difference, the practical difference that this new tax on income PRACA makes. Now, if a QIP who benefits from a tax exemption looks to distribute a dividend, there is no longer any clawback of corporate tax. So then the QIP company only needs to be concerned about the withholding tax on dividend of 14%. And even on the withholding tax, as my colleague Borapyn will explain, the withholding tax rate of 14% can be even further reduced down to 10% when there is a double tax agreement in place between the shareholder and the QIP. Next slide, please. Okay, so now we move on to the proposed incentives under the new investment law. So it's a little bit same but different, which I will illustrate in the next slide. So here you can see under option 1 of the new investment law, we have the same exemption as currently exists for QIP. So a QIP would still be eligible for this tax on income exemption, which can go up to 9 years. There will be some further detail as to the qualification criteria for various sectors and activities. But the key difference with respect to the new investment law is following the conclusion of the tax on income exemption, we now have a 6-year period where a QIP can benefit from a reduced tax on income rate. In addition, what's also new is that a QIP can also be exempted from minimum tax if they evidence that they have obtained independent audited financial statements. Now, the minimum tax exemption is interesting insofar as it used to apply under the current investment law to all QIPs. And perhaps to explain this further for those who are not familiar with the tax regime in Cambodia, Cambodia is a little bit unique compared to most jurisdictions insofar as the corporate tax that you pay at the end of a tax year is the higher of the 20% corporate tax rate on your profit, or 1% on your annual turnover, so whichever is higher. So minimum tax essentially is a turnover tax of 1%. Now, historically in Cambodia, all QIPs were exempted from minimum tax during the life of the QIP. Then that was changed a few years ago, and the new rule was that to be exempted from minimum tax, all taxpayers, including QIPs, had to evidence to the tax department that they had proper accounting records, and that required a taxpayer to get a formal approval from the tax department, which was not a particularly straightforward process. So now for QIPs, QIPs only need to evidence that they have obtained an independent audited financial statement, which we hope would be a lot easier process than the current process of evidencing proper accounting records. Next slide, please. So again, just to recap the proposed incentives under option 1 of the new investment law, we have the same tax exemption period as before: trigger period, holiday period, priority period. But now we have this reduced tax on income period of 6 years following the conclusion of the tax exemption period. And then after those 6 years have been completed, the QIP would then pay the standard corporate tax rate of 20%. Next slide, please. So to illustrate this even further, we have the example here where we have the tax exemption period. We've taken a very basic case of 3 years. So in that 3-year period, the QIP would be permanently exempted from corporate tax or tax on income of 20%. And then in the next 6 years, we have this reduced tax on income rate, whereby year 1 and year 2, a QIP would only have to pay 5% corporate tax. Year 3 and 4, the QIP only has to pay 10% corporate tax. And then years 5 and 6, the QIP only has to pay 15%. Now, the wording here is quite important, and the way that this is currently worded in the law on investment is that the tax exemption period does not include this reduced tax on income rate. So what that means under the current regulations is that for this 6-year period where a QIP can qualify for this reduced tax on income rate, it's a little bit the same as what it was before under the old law on investment, whereby you get this saving up front, but then at the time that you distribute a dividend from the retained earnings that have benefited from that reduced rate, there will be a clawback of the residual 20% tax on income. So to give you an example, in 2025, you're a QIP, you have profit, you only have to pay 5% tax on income. But then when you go to distribute that profit as a dividend, under the current law, the tax department would require you to claw back the 15%, which is the difference between the 5% and the standard corporate tax rate of 20%. So this additional incentive, the way it's currently worded, to us is not a permanent tax exemption. It's more of a suspended tax exemption. And this is where the tax planning still comes into place, which Borapyn will touch on more in his section. Next slide, please. So under option 2, a QIP under the new investment law is able to claim or to ask for a special depreciation rate of 40% on tangible assets. That's exactly the same as the current investment law. So there's no change there. But what is different is that in addition to this special depreciation rate, a QIP can also obtain a 200% deduction on what's phrased as significant expenses for up to 9 years. So for every dollar spend, the QIP would get back a $2 deduction. Now, quite frankly, we wouldn't expect too many investors to choose option 2, given that QIPs in Cambodia now have a permanent exemption on tax on income. It doesn't really seem to make sense in most cases to choose option 2. Option 1 to us would be the default option for most QIPs. Next slide, please. So some additional incentives. So for export and supporting QIP. So export QIP, as the name suggests, is a QIP that exports most or some of its products outside of Cambodia. A supporting QIP would be a QIP that provides goods to a export QIP. So for export QIPs and supporting QIPs, they can, under the new investment law, import construction material, equipment, production equipment and inputs, and they would get a custom duty exemption, which currently exists, but they would also get a exemption on excise tax, or sometimes referred to as specific tax, and they would also get an exemption on VAT. Next slide, please. For domestic QIPs, which are QIPs that would be providing goods to the local market in Cambodia, domestic QIPs can import construction materials and equipment and import production equipment with also an exemption of custom duty, excise tax and VAT. For domestic QIPs, the type of production inputs that will get this exemption will be determined by a further regulation. Next slide, please. So in addition to all of the above, all QIPs are eligible for the following exemptions. So all QIPs under the new investment law would be eligible for a exemption of VAT when they purchase production inputs from Cambodian suppliers. In addition, all QIPs, if they carry out certain expenditure such as R&D and innovation, or expenses which provide some type of tangible benefit for their employees, such as a canteen or a food court, or some type of accommodation facility for their employees, all QIPs would be able to obtain a 150% deduction, which means that for every dollar spend of these expenses, the QIP would be able to claim $1.50 back as a expense. And that's for the life of the QIP. Next slide, please. And then we have this additional kind of catch or clause whereby the investment law provides that the government can award additional incentives to any QIP which has an activity which is deemed to contribute with a high potential to the national economic development of Cambodia. So the government has the discretion to go above and beyond the standard incentives in the law on investment and provide even more additional incentives on a case-by-case basis. Next slide, please. Okay, so some overall comments with respect to these incentives. So as I mentioned before, the minimum tax exemption now, which only requires proof of audited financial statements, we hope will make it a lot easier than the current process for QIPs to be exempted from this annual minimum tax obligation. With respect to the VAT input incentives, this does provide, we can see, two tangible benefits. One is that from a cash flow perspective, obviously not having to pay VAT on certain imports and not having to pay VAT on the procurement of local inputs from Cambodian suppliers is beneficial from a cash flow perspective. But perhaps even more beneficial than that is that it will allow QIPs to avoid the current VAT refund process in Cambodia, which we can say is less than ideal when it comes to the efficiency by which a QIP can expect to receive a VAT refund. So by exempting VAT on imports, for example, or local acquisition of imports for an export company, which would never have a VAT output situation and would only be able to get that VAT input back via a refund process. This would help those export QIPs to hopefully avoid this current problematic VAT refund scenario, which can take a significant period of time to process a VAT refund request. Next slide, please. So with the custom duties, we don't really see that much of a tangible benefit with respect to the custom duties. Of course, custom duty exemptions currently exist under the current law on investment for QIPs. But in addition to that, Cambodia has a pretty extensive portfolio of free trade agreements whereby most goods and materials that are now imported into Cambodia, be it by a QIP or be it by a standard taxpayer, most of those would be already heavily reduced with respect to the tariff rate or the custom duty rate. The proviso typically is that the importer would need to evidence a certificate of origin to be eligible for those incentives. So custom duties we don't really see as a large incentive. Excise tax, however, is a tangible incentive insofar as under the current investment law, excise tax is not exempted, and under most free trade agreements that Cambodia has signed, excise tax is also not exempted. So excise tax or specific tax applies to certain goods which are imported into Cambodia, and quite often the rates can be quite high. So having this exemption in place under the new investment law does provide some tangible benefit. Next slide, please. As I mentioned before, this option 2, with respect to the special depreciation rate, along with the 200% deduction, we don't really see the benefit of this would outweigh the permanent tax on income exemption benefit under option 1. because realistically speaking, when you are in your permanent tax on income exemption, which can be up to 9 years, you don't really have to worry about expenses, because you know that when you distribute your dividend back to your shareholder, there's not going to be a clawback of the corporate tax at that time. So it seems like looking to utilize your expenses in your first 9 years or up to 9 years is not really going to be a significant reason to choose option 2 when you have this option of the permanent corporate tax exemption. The 150% deduction on expenses such as R&D or staff benefits, again, if you're looking to be eligible for this permanent tax on income exemption, perhaps not so important, but one of the key points to note is that this new investment law, it doesn't just apply to new QIPs, it also applies to existing QIPs. So potentially an existing QIP which has already exhausted its tax on income exemption period, it could benefit or be encouraged to invest in these activities because it knows it would get a 150% deduction expense, which would obviously help it to offset corporate tax if it was in a profitable situation. Next slide, please. So while we're painting a fairly rosy picture about this permanent tax on income exemption, there is a few warning signs, and it's something which Borapyn will go into in more detail in his section. But on face value, you would think that you wouldn't have to worry about implementing intercompany charges such as a management fee or a royalty during the tax on income exemption, because effectively you don't have to worry about expenses because you have this permanent exemption from corporate tax. However, you have to realize that the corporate tax exemption does not last forever. And even during this 6-year period where you have a reduced corporate tax rate, the tax department can still, under the current wording, claw back or expect you to claw back the corporate tax at the time of a dividend distribution. So it would be a little bit cynical and a little bit short-sighted for a QIP which had a 9-year permanent tax on income exemption in year 10, when it was going to be subject potentially to tax on profit, to then start introducing management fees or royalties, because I don't think the tax department in Cambodia would be so naive or so accepting to say, oh, you didn't have a royalty in your first 9 years, but now we're going to accept that you have a royalty when you're going to be exposed to corporate tax. So you do have to be a little bit careful and still put in place some tax planning as to when you look to introduce these intercompany charges. Next slide, please. Okay, so that's a nice segue into my colleague Borapyn's section on the holding the Cambodian investment. Thank you.
Thank you, Clint. Good morning, everybody. My topics, I will be discussing on the jurisdiction in which the investor had to set up a holding investment to hold the investment in Cambodia, in addition to the incentive and tax incentive provided under the law on investment and also the law on taxation. There are two main areas that investors need to look at to accept this or to choose the country that to set up a holding company to hold the investment company in Cambodia. First is about the double tax agreements and the transfer pricing requirements. Why are they so important for the investor to think of about this kind of arrangement? First is about the Cambodian tax implication, because when you have a profit, when your investment company has a profit, the investment will cost in the first 9 years. The investment is subject to tax exemption, provided under loan investment. However, after 9 years, the investment will pay the 20% income tax, or we can say tax on income. And then if the investment make the profit repatriation to the holding company or to the shareholder, the company needs to pay the 14% withholding tax. In addition to that, after the profit tax on income exemption finished, the investment company is subject to the reduced tax on income. But in this reduced tax on income, when the investment remit the dividend back to the shareholder, there is a clawback of the tax on income in this. Clint already explained that the investor will pay the additional tax on dividend. Next slide, please. Okay, double tax agreement. DTA is a bilateral mechanism that both countries agree to remove the double taxation or to reduce the certain tax on certain payment for the cross-border transactions. Currently, Cambodia has signed the with 10 countries. We have Singapore, Thailand, China, Brunei, and Vietnam, Hong Kong. And recently, we just signed with Macau. But only 8 of the 10 DDA that Cambodia has signed has been put into force. The other 2 DDA with South Korea and Macau will be implemented in. But for Macau, it needs to be determined. We are not sure it will be implemented or maybe delay further. It depends on the both countries will agree on the effective date. To my knowledge, we also understand that there will be more coming. Currently, the Cambodian government is negotiating with Laos, with Myanmar, and also with Japan and also Philippines. So we expect to have these 4 DDA will be signed in the coming years. One of the main tax aspects agreed on the DDA is withholding tax. So in the Cambodian withholding tax regulation, when the taxpayer make a payment, for example, royalty, dividend, interest, fee to a non-resident taxpayer, the Cambodian taxpayer has to withhold 40% withholding tax. However, under the DDA, this withholding tax rate is from 14% to 10%. It doesn't mean that all the DDA that Cambodia has signed with the withholding tax has to be reduced from 14% to 10%. There are 2 exceptional DDA with China and Thailand. If the Cambodian taxpayer make the interest payment to the Chinese state-owned bank, the interest, the withholding tax rate will be 0, not 10%. In addition, with DDA with Thailand, it doesn't apply to all the recipients in Thailand. The 10% reduced withholding tax will be applied on the interest payment or on the payment which will be received by the financial institution or insurance company. And also when the interest payment made to the state-owned bank or government institution in Thailand, the withholding tax will be 0%. Next, please. I just briefly discussed about the withholding tax implication in Cambodia. Withholding tax requirement that when a resident taxpayer makes a payment to non-resident, the Cambodian taxpayer has obligation to withhold the withholding tax on the payment before it is paid to the non-resident, and to remit this withholding tax to the tax authority on monthly basis. There are many payments to non-resident. I just only pick the 4 main payment which is related to the payment under the DDA. First is interest payment. Second, when it's on the dividend payment to the non-resident shareholder. Third is compensation for management and clinical, and fourth is the royalty payment. I just go back, please. I just want to discuss on the management and technical fee. This term, the management and technical fee, has already defined under the Prakas 098. However, before the issuance of the Prakas 098, it was not defined. In practice, the tax authority has broadly interpreted capture all service payments that the Cambodian taxpayer pay to the non-resident as the management and technical fee, and then they impose the 14% withholding tax. But now, under the Prakas 098, this term management and technical is already defined. So for the management service is referred to a service with a managerial characteristic performed to complete the managerial function in business, including like staff recruitment, training, and management of sales, etc. And for the technical service, it is referred to a service with a technical characteristic requiring the technical skill or knowledge in the development the business input. So, for example, like scientific, physical, chemical, dental, medical, legal, and consulting service. So those are can be defined as a technical fee. In addition to withholding tax implication, under the rule, withholding tax is payable on when is recorded, or when the company makes the payment to the non-resident. So when which of the two events happen first, the withholding tax will be payable. So in this case, it is advisable that the company need to check or review the agreement or service agreement before they record the expense. In case that they have recorded the expense, but they have not get the DA approval from the government, they have to pay 14% withholding tax. So that's why it is suggestible that we need to look at the agreement or the expense, whether you can defer the payment to be recorded after the you get the approval from the government or the DDA. Okay, and in addition to that, DDA approval is not a lifetime The Cambodian taxpayer need to apply to the Cambodian tax authority on yearly basis, get the approval before you can withhold the tax based on the reduced withholding tax under the DDA. The reason is because the status of the person who will receive this income in the contracting party may change. It's required under the DDA. Jack will further discuss about the tax residency section on this point. Next slide, please. As I mentioned, it is not a automatic. The DDA is not automatic. You need to get the approval first before the company can apply the reduced withholding tax under DDA. The Cambodian taxpayer has to submit the application on behalf of the person who will receive the income in the contracting party to the GDT. The GDT will review the document. If the document meets the condition under DTA, especially on the rate tax residency of the person who will receive the income, the GDT will issue the approval to the taxpayer, and then you can use the withholding tax for the purpose of paying the withholding tax. Next slide, please. These are the main documents that you need to submit to the tax authority for the purpose of obtaining the approval of the DTA. First is a certificate of tax residency. This is very important document because this approval is not really the approval for the Cambodian taxpayer. It's the approval for the person who will receive income in the contracting party. For example, like a person who in Singapore, the person will receive the income from the Cambodian company. So to be eligible for the use withholding tax under DA, the person has to be a tax resident in Singapore. So that's why the Singaporean government will issue a tax residency certificate to that person. So the company needs to submit this certificate to tax authority in Cambodia to prove that this person is a Singaporean tax resident. And the other four documents is more on the corporate document of the Singaporean company. So this means that the Cambodian taxpayer in Cambodia is a representative of the Singaporean company or Singaporean person to apply this request to the Cambodian tax authority for the approval of DTA. Next slide. Next, please. Okay. I just want to provide this scenario on the tax implication or tax impact on the profit repatriation. For this scenario, as you can see, we have a Cambodian company which is owned by a Singaporean company. Of course, the Cambodian company is a QIP company. So during the tax exemption period, Cambodian company Camco is not subject to pay the tax on income to the tax authority. So if so it means that it does not provide any benefit to the Camco to have the service, or you can say the intercompany charge to reduce the bottom line of profit, which will be subject to tax on income. Because during the tax holiday period, the Camco will only pay. It's not required to pay any tax on income. So when the Camco make a dividend distribution to the holding company, Camco will only require to hold the withholding tax on the payment of the dividend to the shareholder. With the DDA put in place, or with the approval of the DDA, Camco can apply to Cambodian tax authority to get the reduced withholding tax on the dividend payment, so that Camco will only pay 10% of the dividend 10% withholding tax on the dividend payment to Singapore company. However, after the tax on income exemption finish, Camco, of course, will subject to reduced tax on income period. As Clint mentioned that there is a fallback provision under law on taxation. Camco has to pay the additional tax on dividend distribution if Camco pay dividend from the return earning, which is subject to reduced tax on income. So effectively, Camco still pay the 20% corporate income tax before Camco can make the can pay the dividend to the shareholders. So in this case, it worthwhile for the Camco to have the intercompany charge, so that Camco can have its cost to reduce the taxable profit. So and also with the DDA put in place, Camco also can reduce withholding tax further from 40% to 10%. So effectively, if the Camco has arranged the service or royalty intercompany charge with the shareholder or with the holding company, Camco can save a lot of tax. So in total, the Camco will only pay around 19% the total tax on the dividend payment to the shareholder. Just repeat what Clint has mentioned earlier. Please bear in mind that the tax authority will see that the intercompany charge may be artificial. It's not a real charge. It's not genuine, because during the tax holiday period, Camco has no any intercompany charge. However, when the Camco has the tax on income exemption period conclude, Camco has intercompany charge. So the tax authority will view that, okay, look, this is not a real charge, so we don't agree on the service charge, and then they will remove or reject this expense. So Camco will end up to pay more tax on the tax on income. So in this case, it's very important that QIP, the investor, need to have a proper tax planning from the beginning. It's not just when your tax on income period finished. Okay, it starts from, I think it starts from the first year, so that service royalty charge is consistent. Consistently charged to the Cambodian investment company. Next slide, please. Okay, with respect to a intercompany charge, this can be treated as a related party transaction. So based on the transfer pricing requirement of Cambodia, the transfer pricing, the taxpayer in Cambodia need to have the transfer pricing documentation, not that the charge from the holding company has been conducted in arm's length principle. Next slide, please. So, of course, not all transactions with party, with holding company, or with other person will be treated as related party. It has to meet the definition of related party. First definition is a Cambodian company has a transaction with the immediate family member. So this transaction will be defined as a related party. Taxpayer has to have the transfer pricing document to support that the fee charged from that person or the price that charged to that person has to be a market price or market fee. The second definition is a 20% of voting right for holding capital. For example, like we have a Singaporean company which is a shareholder of a QIP company. And then a QIP company has a charge from that shareholder, which that shareholder hold more than 20% share in Cambodia. So in this case, this charge from the holding company will be treated as a related party transaction. So the Cambodian taxpayer have to have the transfer pricing document to support this charge that from the holding company, whether the charge is charged with arm's length or not. If it's not an arm's length, that also have rights to adjust the price or adjust the expense. So the company in Cambodia will have to pay more tax on that adjusted income or adjusted expense. Under this broadcast 986, previously it was defined 51%, but under this new the broadcast tax or transfer pricing guideline, the use of working power holding share to 20%. It means that the scope of the related party is expand now. So the tax authority will have the company may more subject to the transfer pricing requirement under the transfer pricing requirement. Next, please. Yep, the transfer pricing in concept, it's the tax authority. The tax authority want to see that the price charge that between a related party is the same as the price charge between unrelated parties. Okay, of course, commercially it doesn't work like that. When you sell your product to a related party, or you get a charge from your related party, definitely it's not the same as you charge to the unrelated party, because the price that you charge from related party is a controlled transaction. That is why the tax authority require you to have the transfer pricing document to show why you charge at this price. Because there are a lot of factors that the party need to take into account: the risk that the party has taken, the function of the party has performed, the economic factor, the characteristic of the product. So those are factors that need to be studied under the transfer pricing guideline. So if you charge less than your price that you charge to a related party, less than or cheaper than the price you charge to unrelated party, you have something to prove that look, we have less risk. That's why we sell the price lower than the price that we charge to unrelated party. Some sort of this study need to be put in documentation to prove the government. And in addition to that, the transfer pricing we look at on the substance, not only the principle, or not only the form. Sorry. So it means that you just can have the invoice from your related party and prove that okay, look, this is the expense charge from the holding company. From the transfer pricing perspective, no, they will look at of course, they will review the transfer pricing documentation, and then they will ask further the supporting document or supporting evidence whether this service has been actually performed by that person or not, and it is really consumed by the Cambodian company or not. Without further supporting document, the tax authority will, okay, look, we don't agree with this expense. We will remove this thing from the tax on income calculation. And then, of course, you have to pay more tax on income. In case that you don't have the supporting document or you cannot substantiate your the expense. Next slide, please. This is just an example for you. On annual basis, taxpayer in Cambodia need to disclose the related party transaction information to tax authority. Every year, when you file your annual tax on income return, there is a page of a list related party transaction. So taxpayer need to fill in this the related party transaction on this form and submit to the tax authority. Next slide, please. Okay. This is a late party loan. I think it's very how to say, it is the issue of the investor in Cambodia so far, because it's not very clear under the regulation issued by the government. Before the transfer pricing guideline was issued, there was a circular 151. Under this circular 151, the tax authority does not allow the tax auditor to apply the DIM approach on the interest-free loan. So what does it mean here? When you have an interest-free loan, the tax authority, before the circular 151, the tax authority will apply the market interest on the interest-free loan, and then they impose the withholding tax on that deep interest. So under the circular 151, the government did not allow them to use this approach anymore. So it means that the party can have the interest-free loan. However, under the transfer pricing guideline, every party transaction has to conduct it arm's length. So it means that when you have a related party loan, you need to have the interest charge on that loan, and the interest rate has to be the market rate. And later on, the government, the tax authority has issued a circular 4909 and telling the taxpayer, look, you can have the interest rate below the market interest. What does it mean the market is? What does it mean on that? Whether the taxpayer can have the interest below or not. Based on my experience so far, we have assist our client in applying to the tax authority for interest-free loans, but the tax authority haven't agreed on that. But they agree on the proposed interest rate, which is of course below the market interest rate. So we don't know whether the other taxpayer can get the approval from the GDT on the interest or not. But from my experience, we have not received any approval from the GDT on interest-free loan. But of course, you can propose the rate to the tax authority. In order to get approval from the tax authority to propose the interest rate, you need to have the four main document below. You have to have loan agreement. You must have business planning with respect to your borrowing, and you have to have the document explaining how you arrive with interest rate. And of course, you need to have the court resolution to agree on this borrowing. Okay, I think I finished my part. My tax planner Jack will discuss further about the tax residency. So Jack, over to you. Thank you so much for your attention.
Good morning, everybody. So in this next section, we're going to quickly look at some of the international tax issues that you need to bear in mind with any form of tax planning involving double tax treaties and Cambodia. So rule number one of applying a double tax agreement is that it requires two residents. So we already know that our company in Cambodia is a Cambodian resident, but then the question is that who is the other resident? And this is essential because in applying for tax treaty relief or DTA relief in Cambodia, the first question of any tax official will be, show me the certificate of residency of the foreign company or individual. That's how you access the DTA. So it's a very important concept, residency, and it's something that is usually applied on a yearly basis. So the question is that in all of this tax planning that we talk about under DTAs, all of the tax planning that Borapyn has mentioned regarding dividends, regarding interest, regarding management fees, and what we're coming to next after this will be around exit planning that we will discuss with Clint about if you sell a business in Cambodia, you sell shares or you sell assets in Cambodia, how is that taxed, and is there potential relief or protection available under the double tax agreement between Cambodia and that foreign jurisdiction. So it's very important to understand that Residency is a concept that's defined under a country's, it's not defined under a DTA, it's defined under a country's own tax laws. So if we take the case of Cambodia, a Cambodian company is a resident if, what is the test? A Cambodian company will be resident if it's incorporated, a registered company in Cambodia. But if we look at other countries, is the same rule applied? And the simple fact of the matter is it's not. There's generally two rules with applying residency under domestic law. There's where your company is registered incorporated, or where the management exercise control for that company. So let's take a practical example. In Cambodia, we know that if I establish a company in Cambodia, that company is a resident, which means that if my Cambodian company is doing investment overseas, and I want the other way around, I want to get relief under the double tax agreement between Cambodia and that foreign jurisdiction, I will go to the GDT and get my certificate of residency for my Cambodian company because it's registered in Cambodia. But if we take the case of, say, Singapore, which is the most common holding jurisdiction for holding investments, not only in Cambodia, but all of Southeast Asia. So Singapore is the jurisdiction that will be used for Cambodia, for Laos, for Vietnam, Indonesia. It's a very common holding jurisdiction. So what are the rules in Singapore? So if I'm looking at the case where I want to have my shareholding company to be based in Singapore because I want to benefit from these DTA benefits that Borapyn has already highlighted, because remember, the great thing about a DTA is that it protects you from any changes in domestic tax law. So Cambodian tax law may change next year, may change the following year. Withholding taxes may increase, they may go from 14% to 20%, they may go to 30%, but the double tax agreement will always protect you against those changes. So this form of tax planning is very important to protect shareholders and to mitigate any unwanted tax exposures on cross-border payments and payments back to shareholders. But if we take the example of Singapore, so just to highlight the issue of residency with tax planning, and we look at it from a Cambodian perspective. But I put on the slide here exactly, this is not my wording, it's not DFDL's wording, this is the Singapore Tax Authority's wording. In applying for residency for a company in Singapore, they will look at specific requirements. So the first requirement is that the management of that company must be conducted in Singapore, and I would say they witness that by having board meetings. Board meetings are conducted in Singapore, and the minutes of the meetings will show that the board of directors conducted their meetings in Singapore. The strategic decisions for that business were conducted in Singapore. Not only that, but they have specific requirements to be resident in Singapore. And I'll just show you quickly, without going into too much detail about Singapore tax law, but you'll see in the list of requirements that it's must have related companies in Singapore that are residents of Singapore or have some active business. And by active business, we mean you're trading in Singapore, you're selling things, you're providing services, or you receive some support or administrative services from a related company. So you've got another company in Singapore, or you have at least one executive director based in Singapore. And the word is executive, which means that they're full-time, that they're there and not just a nominee, not somebody who is just paid a fee to be, tick the box director, or you have at least one employee. And the example that they specifically give under Singapore tax law is a CEO, CFO, or COO, Chief Operating Officer, is based in Singapore. So the idea of putting these planning together when we're looking at, say, Cambodia, where yes, we need to look at it. We want the DTA benefits, and in the long term, there's going to be a lot of savings for our investment in Cambodia as we're paying back our dividends to our shareholders. We've got we plan on expanding in Cambodia, and we're going to have some shareholder loans. We're going to have some royalty payments because we think that a certain product or intellectual property is going to do very well in Cambodia, and therefore there's going to be royalty payments. Or we're looking at exit planning, so we're going to sell our investment at some point in the future, and we're going to look at protecting ourselves from capital gains tax in Cambodia. So in order to implement this, there's other requirements that you need to look at. It's not just from a Cambodian perspective. You will need to have a look at if I'm going to establish a company in, say, Singapore, will I meet the residency requirements in Singapore? And by doing that, you will need to be able to demonstrate that there's certain substance that's there. So an interesting question then is that, well, does everybody apply the same rules as Singapore? And the answer to that is no, because again, residency is determined by domestic law. So if we take a couple of examples quickly, if we look at the countries in Southeast Asia, so Cambodia is based on place of incorporation. Laos, you register a company, it's automatically resident. Vietnam, you register a company, it's automatically resident. Singapore, it's based on place of effective management. Malaysia, it's based on place of management. Indonesia, it's based on place of incorporation. So you need to look at this. Thailand is based on place of incorporation. So in the case of Thailand, you register a company in Thailand, that will automatically be issued a certificate of residency, so you can apply to get access to the double tax agreement between Cambodia and Thailand. But the same does not apply in the case of Singapore, Hong Kong, Malaysia. Now, what you'll find is that the countries that tend to have the better tax systems, Singapore, Hong Kong, Malaysia, do apply the place of effective management. And what you will find is that most European countries will apply the place of management rather than the place of incorporation. So that's really important to bear in mind, that if you're looking at, because Cambodia is expanding its double tax agreement network. Only a few years ago, Cambodia was the only country in all of Asia that had no double tax agreements. Even North Korea had some. And now the GDT has said, okay, well, let's expand our tax treaty network. And now you can see that it's growing at a quick pace. So this form of tax planning is going to become a lot more important. Next slide, please. So I think a few questions to ask for your own business is to look at your shareholders. Are your current shareholders individuals, or are they, is it a company, a holding company? Are they resident in a country that has a DTA with Cambodia? So at some point that, you know, shareholders will want the return for their investment. They will either receive a dividend, they will have a shareholder's loan that will provide some interest to them, or they will sell their investment and realize some capital gains. All of that is covered by a DTA. Borapyn has already mentioned, and we'll look at the capital gains tax issue in a few minutes. So another very important question with this type of planning is that it's all well and good, and it's great that we can use DTAs to help reduce our tax burden and make everything more tax efficient. But what is the implications of receiving this income from Cambodia in your shareholder jurisdiction? So if we take some simple examples, is that if we look at neighboring countries, what would happen in a country like Laos who may invest into Cambodia? Yes, there will be some reductions under the DTA, or if we take the case of Myanmar, or if we take the case of Vietnam, yes, there would be some reductions under DTAs. The withholding tax on dividends or the withholding tax on interest may be reduced under the double tax agreement, but that income that you receive from Cambodia will be taxed in those countries. So there's no, is there ultimately a benefit to this? Possibly not. So, but if we look at other cases, what happens in the case of Singapore? Well, in the case of Singapore, or if we look at the case of Hong Kong, or the case of Malaysia, or some European jurisdictions, certain foreign income that would be received from, say, Cambodia would not be taxed. So if we take the case of dividends, so dividends that are received in Singapore from any jurisdiction would not be taxed in Singapore. And if we take the case of capital gains, so if we sell a business, we sell a company, we sell our shares in a Cambodian company, and we realize a big gain, you know, and we're the shareholders and our holding company is based in Singapore. What will happen with that? Well, we're going to look at, under the DTA, the protection that's available shortly on the next slide, but you got to understand that that income that would be received in Singapore would not be taxed. And given that Singapore does not tax dividends, it's a way of having a tax efficient sale of a business and going all the way back to the shareholders with no tax. Without the DTA, you would pay the 20% corporate tax. You'll be paying dividend taxes. It will get, you know, it won't be very efficient. And as Clint and Borapyn have mentioned, that this form of tax planning is very important, but you should look at it from a long-term perspective. And there's no point in trying to engage in this, you know, 2 days before your QIP finishes, or 3 days, you know, a couple of weeks before you're planning on selling shares in a Cambodian company. It should be looked at over a longer period, because there's a risk that if you engage in something that's, you know, if you transfer your shares into, say, a Singapore holding company a couple of weeks before you sell it, there's a risk that that would be disallowed, that will be seen as a kind of an abusive tax transaction. So I think you should take a long-term view and have a look at this planning by start asking the questions: where are the shareholders located? Should we be looking at establishing a holding company for our Cambodian investments? Are we going to be paying dividends? Will we need financing to expand our Cambodian business in the future? Is there intellectual property that we will be looking at within Cambodia? Are we going to look at selling our shares in a Cambodian company in the future? These questions will lead you to the point of saying we probably should have a holding company somewhere. Which jurisdiction works best for our shareholders and best for our Cambodian business? So next slide, please. Okay, so I think Clint, I think this is our last section. We'll go through this together, yeah?
Yeah, sure, Jack. So just going to finish off with a few important updates with respect to QIP investors who are looking to exit their QIP. Obviously, at some stage, a investor may want to sell the project to a new investor, or simply wind up the investment in Cambodia. And there have been some really key changes that we've seen in recent times, which have a bearing on the taxes that you may pay in a tax exit scenario. You know, as Stephen pointed out at the very beginning, you get this wrong, and the consequences are pretty dire these days, particularly on an exit scenario. So one of the key updates that we have seen firsthand is this recent development, which was introduced under PRACA 518 in 2017, and then extended in PRACA 372 in 2019. And this goes back to my earlier point that prior to 2017, a shareholder in a Cambodian company could exit via a share transfer and effectively pay close to no tax at the Cambodian level. There may have been a small amount of stamp duty payable, but that would have been payable by the incoming shareholder, and the rate of stamp duty in Cambodia is pretty low. It's only 0.1%. So this was fantastic for the departing shareholder. The Cambodian Tax Authority obviously not too thrilled about that situation. So what the authority in Cambodia, the Tax Authority, have done to sort of get their return of tax is to create a what we would consider a kind of artificial mechanism by which they could tax a share transfer. And how they've done that is that they have, they being the tax authority, have now extended the tax definition of a dividend, which basically means this: if you are a non-resident shareholder in a Cambodian company, and you are transferring your shares, and if the Cambodian company has retained earnings at the time of the share transfer, or if some of the shares that you are transferring were converted from a prior conversion of retained earnings, both those categories will be now treated as a dividend for tax purposes. And so what that means is that withholding tax would now apply on this deemed dividend scenario, which is triggered by a share transfer. So legally, there hasn't actually been a distribution of dividend. This is only a tax definition to allow the tax department to try and recover withholding tax from a share transfer. So when the incoming new shareholder comes in, and down the line, if they were to distribute a dividend, a legal dividend distribution from the same retained earnings that were taxed at the time of the share transfer, then they wouldn't have to worry about withholding tax at that time. So all this basically means is that the tax department can tax a dividend at the time of a share transfer without having to wait for a legal dividend distribution down the road. Next slide, please. So what does this mean? Well, as you heard from Borapyn and Jack, dividends can also be eligible for a reduction in withholding tax if some criteria are met. So if you were transferring shares in your Cambodian company and you know that you're going to have this deemed dividend issue, then you would want to get this DTA approval prior to the transfer of the shares to reduce your exposure to the withholding tax from 14% down to 10%. What about indirect share transfers? So by indirect, we would have the example of a Cambodian company with say a Singaporean shareholder, and you have, say, the individual shareholders holding shares in the Singaporean shareholder. So if those individual shareholders were to transfer shares in the Singaporean company as an indirect share transfer, then at the moment this deemed dividend issue wouldn't apply. But as we'll discuss later, we cannot look into the future with certainty, and the tax department can change their approach over time. How does the capital gains tax regime, how will that impact this deemed dividend situation? Well, practically speaking, the deemed dividend regulation is a distinct tax from the capital gains tax. So capital gains tax, as we'll see, looks to tax the exiting shareholder on gains that they make from the share transfer, whereas the withholding tax on deemed dividend is looking at a dividend distribution. So they are two quite separate things. Ultimately, the tax department in Cambodia will want to gather or obtain as much tax as possible from share transfers. So it's more than likely that they will keep both the deemed dividend and the capital gains tax, unless there is some big pushback from the private sector in Cambodia. Next slide, please. So capital gains tax has got quite a lot of press in Cambodia in recent times. It was originally supposed to be introduced in July 2021. However, there was at the time a great deal of pushback by the real estate sector in Cambodia, because it was going to affect predominantly individuals who were selling real estate in Cambodia, and they were not particularly happy about that. So the implementation date of the capital gains tax regime was delayed until 1 January 2022. Capital gains tax, the rate is the same as the corporate tax rate, which is 20%. applies to individuals, as I just mentioned. It also applies to non-resident taxpayers, be they individuals or legal entities. And importantly for this discussion, the definition of capital includes shares. So the transfer of shares in a Cambodian company would be captured by the capital gains tax regime. Next slide, please. Now, double tax agreements, as Jack alluded to with Borapyn, they can provide some quite effective shields against the ability for the Cambodian tax authority to tax capital gains tax on share transfers once this regime is imposed from next year. So the general clause in most of the DTAs that Cambodia has signed basically provides, with respect to capital gains, that it's only the state of the party who is actually deriving that gain would be the state that would be allowed to tax a gain. So if we had the example of a Singaporean tax resident who had shares in a Cambodian company, if the Singaporean tax resident was to transfer their shares and make a gain, under most DTAs, Cambodia would not be able to tax the gain. It would only be Singapore that would only be able to tax the gain. Now, there are some exceptions. For some reason, in the Cambodia-Thailand DTA, Cambodia was able to keep its taxing right when it came to capital gains. So be aware, if you're planning to have a Thai holding company for a Cambodian investment, you would be exposed potentially to capital gains tax on a share exit scenario. And the other key distinction is with respect to Cambodian companies which hold immovable property, which makes up 50% or more of the value of the company. So in those situations, the Cambodian government would still have the ability to tax gains. So aside from those two exceptions, the DTA network does provide quite a comprehensive shield for tax residents and those other jurisdictions from the implications of the capital gains tax regime in Cambodia. Next slide, please. Next slide. So in our experience, some of the more common holding company jurisdictions for Cambodian investments would include Singapore, Hong Kong. Thailand is popular, as well as Malaysia, which under the DTA with Cambodia would also encompass Labuan. So in all of those jurisdictions, with the key exception of Thailand, there would be this potential shield against the capital gains tax regime in Cambodia. But the key point to note, I think, on this issue is what Jack raised. Just because you set up a company in Singapore does not mean by default you can benefit from the DTA exemptions, in particular, in this case, the capital gains tax exemption. If you are not able to obtain a tax residency certificate from the IRAS in Singapore, then you're out of luck. The Cambodian tax authorities would still be able to tax capital gains on your share transfer after 2022. So yeah, please bear that in mind when you're looking at these jurisdictions, that in some cases there is a degree of substance that you need to implement to get this this benefit. Next slide, please. So I'll just give you some key points on some fairly common scenarios. So in this case, we have a Cambodian company which is wholly owned by a Singaporean entity, and the Singaporean entity would be looking to potentially exit via a direct share transfer in the Cambodian company. So some of the key points to take into account would be withholding tax implications on the deemed dividend that I mentioned. So if the Cambodian company has retained earnings, or if some of the shares had previously arisen from an earlier conversion of retained earnings, then the Cambodian company will have to pay withholding tax at the time of the share transfer. Capital gains tax from 1 January 2022, if the Singaporean company can obtain a tax residency certificate and can evidence that it has the substance requirements that Jack alluded to, then capital gains tax will not apply in Cambodia. And of course, Singapore doesn't tax capital gains tax either, so that's obviously a plus. Stamp duty, 0.1%, payable by the company who is acquiring the shares from the Singaporean shareholder. Quite often, in our experience, the incoming shareholder would want the Cambodian company to produce a tax clearance certificate, basically showing the incoming shareholder that there's no skeletons in the closet when it comes to historical tax issues, and that can take some time to obtain. Under the new investment law, it's possible for a new investor in an existing QIP to still be eligible for the ongoing incentives, but the key thing is formal approval would need to be obtained from the Council for the Development of Cambodia prior to the share transfer. Next slide, please. So scenario 2, we would have a indirect transfer of shares. So in this case, those 3 individuals at the top of that diagram would be selling their shares in Singco to a new investor. Cambodian withholding tax implications on the deemed dividend, the answer to that currently is no, but there's a big proviso that there may be developments in the future. And one of the key things we're seeing now is the ability for the tax department in Cambodia to go back and audit. So the tax department typically can go back up to 3 years to audit a taxpayer, but that 3 years can be extended to 5 years and ultimately to 10 years if the tax department believes there has been some type of tax avoidance or evasion taking place. Can you go back to scenario 2, please? Yeah, so with respect to the capital gains tax on an indirect share transfer, we're not sure at the moment. We're still waiting for additional regulations to be passed on the implementation of capital gains tax for share transfers. Stamp duty on an indirect share transfer would not be applicable in Cambodia, but would probably be applicable at the Singapore level. The tax clearance issue still remains the same. What would be interesting, and perhaps Jack, you can have a few words on this, this is where tax indemnity really comes into play with respect to trying to anticipate that the current practice of the tax department may change over time. And so someone who's looking to acquire shares in a Cambodia company, either direct or indirect, may need to take this into account. Maybe Jack, you have a few words on this?
Yeah, so at a basic level regarding tax and collecting tax, you can only collect tax within your own borders. You can't cross-border enforce a tax. So if, in this case, if the shareholder sold the shares and the tax wasn't paid and the shareholder was living in, say, I don't know, pick a jurisdiction, Cayman Islands, Cambodia cannot go after them in that jurisdiction. There's no way to do it. So what can Cambodia go after? They can go after the Cambodian company. And this is what we see in practice. So what we're seeing across Southeast Asia now is that this topic of indirect taxation is becoming very hot. So what we've seen in recent years is that many jurisdictions now realize that there has been transactions taking place offshore, be it a couple of tiers of holding companies up, and that they weren't collecting what they felt was their due tax on gains related to assets in their jurisdiction. So what we've seen is Vietnam has introduced rules, and they do go after cases, particularly where they see a case in the newspaper or on the news where it's a big company that's exiting Vietnam. They will go after that as quickly as possible. Laos has recently, I'm aware of 2 cases there, big cases where they've gone after indirect transfers. Myanmar has introduced rules into their domestic law. Indonesia has the rules there. China has the rules there. Thailand does not have the rules there, but you can see where all of this is going. And from a tax planning perspective, knowing that if you're doing a deal, that if anything goes wrong down the road, and things do go wrong, unfortunately, with taxes, is that it will only be the Cambodian company that can be chased for that tax. And we've seen there's a very famous case in India that everything's kind of based on. Vodafone, the mobile phone operator, had sold their had bought assets in India. The assets were sold at an offshore level. The seller of those assets are gone. They're in Hong Kong, and now the Indian tax authorities are asking the Vodafone India, you've got to pay this back tax, because they can't go after the seller. They can only go after the Indian company. The same in Cambodia. So what do you do to protect yourself there? If you're going to be selling, if you're going to be the buyer, I guess, on these things, is that you put a tax indemnification clause into your sale and purchase agreement. And if there is any change in the capital gains tax regime, if we are hit for this tax later, which is a tax of the seller, that we can, you will pay us back this tax at a later stage. Because if you don't include that, you're 100% guaranteed that the Cambodian tax authorities will go after the Cambodian company, because they cannot go after the seller. And what happened in the case in India, the famous case, was because at the time there were no rules under Indian domestic law. What happened was India issued new rules and then backdated them. They backdated the rules to way back, so that gave them the power to tax these transactions. Who's to say that that won't happen in Cambodia? But either way, in the Vodafone case in India, they did not include a tax indemnification clause. So it meant that the Indian company has got big problems, and it's a $2 billion tax case to deal with. So from a protection perspective, if you're the buyer, you should be looking at having clauses with the seller that if at a later stage Cambodia decides to tax these in an aggressive manner, the way Vietnam is doing, or Indonesia is doing, or China is doing, is that you can go back to the seller for some recourse, because knowing that 100% sure that the Cambodian tax authorities will go after the Cambodian company for these taxes. Clint?
Yeah, Jack, and maybe just to go even further. I mean, we have seen this firsthand in Cambodia. I mean, we could give the example of share transfers that may have occurred back in 2018 and earlier, where the new shareholder has come in, and only in the recent times have these Cambodian companies been subject to a tax audit, and the tax auditor is now going after the Cambodia company for taxes which in theory should have been paid by the exiting shareholder at that time, but of course without an indemnity, the company and the new shareholder are kind of stuck holding the baby, so to speak, and then have a fun negotiation with the Cambodian tax authorities to resolve the issue.
One other important point I think just to raise is that it shows the importance of direct transfers. So in the example that we see, if it wasn't the shares in the Singapore company, but the shares in the Cambodian company that were sold by the Singapore company, there's protection there. And Cambodia, providing that the Singapore company is a resident of Singapore, there's nothing Cambodia can do. It has no taxing rights over those gains. But in the case where we see that we have individuals selling shares in the Singapore company, that would not be covered by the Singapore-Cambodian double tax agreement because it's outside the scope of that. But a very important aspect to note with indirect transfers is, in that case, we would have to have a look at the resident state of where those individuals are. So, for example, if they were in Hong Kong and you're Hong Kong residents that sold shares in the Singapore company that owns the shares in the Cambodian company, we would apply the Hong Kong-Cambodia tax treaty. So it's important that you look at this, you know, the full spectrum. It would still, just because it's shares in a Singapore company, it does not rule out the fact that the Hong Kong and Cambodia tax treaty would apply. So you have to be careful with this, that there may still be protection there, but the easiest way to do it is to do, you know, as we've seen, the direct sale, where if the Singapore company had sold the shares in a Cambodian company, there's protection under the double tax agreement. Cambodia does no taxing rights over it. So what happens is, from a practical perspective, those capital gains from the sale of our shares in the Cambodian company are received in Singapore. It's not taxed because Singapore has no capital gains tax. And then we would pay all of those capital gains as a dividend back to these individuals. And there's no withholding tax on dividends. So what we've done is that the whole transaction would be tax-free, depending on where the individuals are located. You know, whether that country will, you know, is it taxed on worldwide income? Are they, you know, are they in Australia? Are they in America? Are they, you know, it would be a personal income tax issue, but the protection the whole way along the line would be there. So it's a very important aspect of tax planning that should be looked at carefully. But with the indirect transfer, the easiest way is a direct transfer, knowing that you've got protection under the double tax agreement, and there's nothing that Cambodia can do, or they'd have to discard the tax treaty in order to not apply the relief. But if you're doing the indirect transfer, you're running into risks, as Clint mentioned, that potentially what we've seen now in Vietnam, in Laos, in Indonesia, in China, in many countries, is that this is a very hot topic, and it's and where it gets even more complicated, of course, is that if you sell shares in a Cambodian company directly, we can calculate the capital gain. It's the sales proceeds less my purchase cost. But what happens if it's through holding companies and you've got different layers? How do you allocate the asset price to it? It becomes a very difficult and sometimes a messy calculation to do. So there's a lot of risk involved in that.
Thanks, Jack. And then moving to the final slide. Next slide, please. Yep. So on this one here, which sorry, go back, please. Yeah. So on this slide here, we see what is becoming probably a more common scenario, which is not particularly great for the exiting investor, whereby the new investor would say, look, we don't really want to take over the shares of the existing company. There may be a number of reasons for that. They may be concerned about historical tax issues in the existing company. They may want to try and apply for a new QIP, which means that they can refresh the QIP incentives and have a longer incentive period. So in this case, there would be typically a onshore asset transfer or a business transfer. Unfortunately for the Cambodian company, that means that any gain on that transfer would be subject to 20% tax on income, and then the Cambodia company would be obliged in most cases to deregister for tax, and then any distribution of retained earnings as part of that deregistration process would be considered to be a dividend and therefore subject to withholding tax on the way up to the Singaporean company. But we see this more and more from the purchaser's perspective as quite a common structure, whereby they would want to set up their own brand new onshore company and simply bring the assets across from the existing entity. So that's again not an ideal solution for the exiting shareholder, because there would be a number of taxes that they would be subject to, but it would provide, and to Jack's point about the uncertainty with the indirect share transfers, it does provide a degree of comfort to the purchaser that they're not going to be subject to a large tax reassessment down the road for all of these uncertain issues. So that winds up our technical seminar for today. I'd like to thank Borapyn and Jack for their contributions, and I'd like to hand over to Stephen to provide some concluding remarks.
Okay, thank you, Clint and Jack and Borapyn. It's, as I said at the start, yeah, tax. It can be a challenging topic, but it's something that presents opportunities and also significant risks. And for a lot of the transactions that we at MSP work on, tax is often the single biggest risk facing the transaction. So the guys have touched on some of the issues today, but yeah, I think there's as a third party here, we'd have a very strong recommendation that it's really important to go and get tax advice on these issues, and ideally get the tax advice early. Trying to fix something up afterwards can often be far more costly, or you may miss out on some of the fairly significant incentives that the Cambodian government is looking to introduce. So thank you all very much for joining us today. The contact details for the DFDL team are in the invite. On that note, again, thank you, and all the best for the day ahead. Thank you.
Thanks.
Thank you. Thank you.